Chapter 6, Intellectual Property. Part 5, Trade Secrets. The learning outcomes include: articulate basic protections offered by trade secrets, explore methods of preserving trade secrets, apply trade secret laws to software and computer programs, explore pros and cons of non-compete agreements, protect a work made for hire, discuss the impact of injunctions on trade secrets, assess the First Amendment in regard to trade secrets, compare global rules for trade secret protection. What are trade secrets? Trade secrets include business information that represents something of value, required effort and/or cost to develop, is somehow unique, is not known to the general public, and is kept confidential. A simple definition is that a trade secret is a formula, practice, process, design, instrument, pattern, or compilation of information used by a business to obtain an advantage over competitors or customers. Why would we want to seek trade secret protection instead of or in addition to other IP options? Trade secrets don't have a time period. A trade secret is protected as long as you protect it and it remains a secret. You don't have to file an application or make disclosures to get protection like you do with copyrights and patents. Trade secrets can't be ruled invalid by the courts. If you keep it secret, it's a trade secret. Trade secrets are some sort of subject matter that is reasonably secured and has some value attached to it. The subject matter may be financial, technical, marketing, or organizational information. Knowledge about negative results may be considered a trade secret. Think of drugs that are undergoing tests. A company may not share negative results, instead making their competitors do the same or similar testing on their own at their own cost. Subject matter covers a much wider group of business interests than is offered by patents. Trade secrets must be subject to reasonable security. Who decides if it's reasonable? A reasonable person, of course. While a trade secret must be protected, that's not the only consideration. Subject matter and value are also relevant. The value of the trade secret exists because it's a secret. It must give the company an advantage not available to others who don't have the trade secret. You can't simply say that the general public doesn't know. You must also assess how fast others can learn the information through legal methods. When employees move from company to company, they may have to abide by covenants not to compete. The covenant cannot prevent the employee from working anywhere but can restrict legitimate competition. There needs to be a reasonable time period. Again, you can't force someone to never work in the industry again. That's not a reasonable restriction. The geographic area restriction must also be reasonable so that the former employee can become gainfully employed. Some states, however, won't enforce covenants not to compete, and companies need to review their restrictions regularly. For instance, in 2016, Amazon sued Arthur Valdez, arguing that his new job as a high-ranking manager at Target violates the terms of his non-competition agreement that he signed with Amazon. If the employee received a big promotion or a big raise that doesn't match his qualifications, it becomes more likely that the covenant not to compete has been violated. What does our reasonable person say? We don't know yet with this suit. We'll see. You can request an injunction to prevent someone from using your trade secret, but think about it. If they have the trade secret, is it secret anymore? Once the trade secret doesn't exist anymore, the court is likely to decide that the product or service is no longer a secret. Simply put, once a trade secret becomes available online, it's not a secret anymore. Even if you try to remove every trace of the file online, people could have copied it and you could have missed some. Once everyone knows the secret formulation of Coke, then it's not a secret anymore. And if the courts tried to prevent people from using the trade not so secret, then First Amendment rights to freedom of expression come into play. The best plan is to protect your trade secret and make sure it doesn't get out. First Amendment arguments are difficult to overcome in the U.S. Have you seen the movie The Post? If not, you may want to watch it in your ample spare time to learn more about this topic. The New York Times and the Washington Post wanted to publish the Pentagon Papers. The U.S. government asked the courts to intervene and stop them from publishing classified documents on the U.S. involvement in the Vietnam War. The court concluded that, yes, there was a national security risk with the publication of the materials. However, they refused to issue an injunction. Instead, that they found that the First Amendment bar was difficult to overcome. As the court said when an injunction was sought, if a threat to national security was insufficient to warrant a prior restraint, the threat to plaintiffs' trade secrets is woefully inadequate. The First Amendment is cited over and over again by the courts. The right to freedom of speech is widely agreed upon by courts at local, state, and federal levels. It's a very difficult bar to overcome. Moral of the story, protect your trade secrets and never ever let them out. Take a look at these two videos for more information. Does the First Amendment really protect speech and religion? This YouTube video gives an overview of the First Amendment of the Bill of Rights. Next, take a look at Judge Napolitano's comments where he says, "We should be grateful to NSA leaker Edward Snowden." Finally, there is Julian Assange, the founder of WikiLeaks. Have you heard of WikiLeaks? If not, take a look at this YouTube video. WikiLeaks founder Julian Assange is a self-described internet activist. WikiLeaks publishes secrets, classified documents, leaks, emails, or anything else it gets its hands on in an effort to have everything published, no matter the topic of content or its potential impact. Julian Assange is currently in the Ecuador Embassy in London. If he leaves, it's likely he would be arrested and the U.S. would try to extradite him to face charges. Sometimes you choose to go after trade secret violations in a slightly different way. For instance, Apple filed suit against a Harvard University student for publishing trade secrets about an upcoming product release. Details of new product releases are often leaked, and Apple doesn't always want the information to go public. In this case, Apple didn't sue the student for publishing the information, but sued to find out who was the source who had violated Apple confidentiality agreements. Trade secrets are not usually the best options for technology. It's very hard to use trade secret laws to protect information that could technically be determined using reverse engineering. Although you agree not to view the underlying code for an app that you buy, it's still easily accessible. Something like that can't be easily protected as a trade secret. Instead, you might need patents, copyright, trademarks, and most importantly, click-wrap agreements for protection. When you click on I agree, you most often are agreeing not to reverse engineer the product. In summary, trade secrets are protected for as long as they remain secret. Trade secrets must be valuable, secret, and secure. Non-compete and confidentiality agreements balance organization rights with individual rights to work. Agreements on ownership of work for hire should be made in advance and in writing. Injunctions do little to protect trade secrets. Once the secret is made public, it is no longer a secret. First Amendment rights usually trump trade secret protections in the eyes of the court. International laws may vary.